Ms. Sibison, good morning.
Good morning, Your Honor. May it please the Court, I'm Wendy Sibison. I represent Jamal Martin. This is an appeal from two different forms of gun possession. On a certain day in 2006, police were driving around a Dorchester neighborhood looking for a black teenager who had an outstanding warrant. There had been no local crime committed. There had been no local gunfire. My client, Jamal Martin, was a black teenager, and he was walking down the street that the police were cruising along. He became nervous and evasive when they questioned him, and this resulted in his frisk. There are two issues in this case.
Well, may I just quibble with you?
Yes, Your Honor.
He became nervous. He gave them a false information, didn't he?
Well, yes, Your Honor. Actually, I'll go through all the facts. Maybe
Okay.
that's a good idea at this point. Okay, he was on the street at 10:30 in the morning in a purported high-crime area. He had a different body type from the teen they were searching, but they said they still wanted to see his face. Police then made a U-turn when they saw him, and they cruised alongside him as he walked along, ignoring them, first saying nothing, and then starting both of them, both officers, the driver and the driver in the passenger seat, firing questions at him about who he was and what his age was, and he started to answer. So that's the beginning. They're cruising along next to him at his pace while he's studiously ignoring them and starting to fire questions. He gave a name, and then he gave inconsistent answers about his age. And that is, you're absolutely correct, Your Honor. That's the first thing that happened. And so then the officer in the passenger's seat said, pointed out that he'd given these inconsistent answers. He said, well, if you're 17 and you were born in this year, that doesn't make any sense. And then the cruiser stopped. The officer got out, approached him. And at this point, Martin had stopped walking. He then stepped back, and the officer testified he seemed a little bit nervous, like he wanted to run. He was moving his feet around a little bit. And as the First Circuit has acknowledged, nervousness under these conditions is a normal human reaction. The officer at that point was certain he was not the young man they were looking for. But then he said, I want to know if you have any weapons. Do you have any weapons? And Martin didn't answer. He was silent. The officer took that answer as sufficient to establish reasonable suspicion, with all the other things I've just said, that he was armed and dangerous, and said, I'm going to frisk you. And then my client, as he began to frisk him, said, you can't touch me, and pushed his hand away. And the officer then frisked him and arrested him.
Would it have been different if he had just hauled off and slugged the officer?
Yes,
Okay.
it would have been.
Okay.
I think that's correct.
Because then he could have been arrested right there, and
Well, no, I don't think that's the difference. I'm interested. Judge Cordy's question is well taken. The cases say that if something happens that is unrelated to the illegal conduct, let's assume it was illegal conduct, the stop and the frisk were illegal, and the defendant does something that's unrelated and illegal and can be arrested on the spot, then the frisk is justified. It's a lawful search.
Right.
And isn't that sort of what the judge said here, that pushing away of the
Yes.
hand was an assault and battery?
Yes.
Justifying the arrest? and
That's
the search?
correct. And the reason I answered your the reason I answered your question the way I did, Your Honor, is that would be a different case, because all the cases that find that this was an independent act unrelated to the original unlawful behavior by the police officer, they're all violent. Mm-hmm. So I mean, I can't say for sure whether it would make a difference, but it should make a difference. However, having said that, I
it's
also
not what the
think
appeals court decided anyway.
well, that's true. But the better rule of law, and I've cited these cases in my brief, they're out of state, is that when that happens, let's say he hauled off and slugged him, in my opinion, it still ought not to change the fact that that was an unlawful search. The effect should be, the result should be, the evidence as a result of that search should still be suppressed, but the defendant should be prosecuted for his unlawful conduct. That's the proper outcome.
Well, but I mean, they could have searched him incident
Yes.
to arrest
That's what I'm
if
saying.
Well-
they had slugged him. I mean, I gather here that's not what happened.
That's not here what happened, and I don't want to take any more time on this,
Okay.
actually.
Fair enough.
But you're saying what's key here is that they didn't say, "You've pushed me, that's an assault and battery, you're under arrest for assault and battery." If they had done that and searched him incident to arrest and found the gun?
The officer actually didn't say you're under arrest for assault and
Right, he
battery.
did not.
I don't think he did.
No, I
No,
gather he
but
did.
nonetheless, the trial judge found that that supplied sufficient grounds to do that, and therefore it was good enough. I don't think any case that this court has ever issued says that's enough. In fact, this court has specifically said the defendant's action must be unrelated to the unlawful conduct, and where it's an immediate and direct response, I think that's the language that this court used in, I get mixed up between Borges. Immediate and direct response to the illegal conduct, it doesn't mitigate the unlawful search. It doesn't transform it into it doesn't fix the illegal behavior and allow denial of a motion to suppress. So I guess the first thing I want to say, I think those are all the facts that matter, is that this is not a Fraser case. The Commonwealth has agreed that the minute the officer said, "I'm going to frisk you," not when he did it, but when I'm going to frisk you, that's the moment at which any citizen would reasonably believe they're not free to leave. That was a stop. So the question is, at that moment, or maybe even sooner, in my opinion, the stop occurred sooner. This was not, all the facts that I've just described this was not a consensual encounter. Beginning with police cruising alongside a young man.
Our law is very clear that the police have an absolute right to ask you questions. Our law is equally clear that you have an absolute right not to answer and
That's
to
true.
walk away.
That's true.
That's what I'm saying. So that you can't draw anything from that,
From the fact that he did not.
that he kept walking.
Oh, certainly not, Your Honor. And actually, I'm trying to use that fact to suggest that this was a non-consensual encounter, that the only point at which he actually even began to answer the officer's questions was when they continued cruising along right next to him and firing both of them at the same time. The motion judge didn't put this in his findings, but it was uncontested. Both of them at the same
I have a question
time.
for you. Judge Brown talks about, in his dissent about
Yes.
the tension
Yes.
that's there between the police response to danger
Yes.
and the Fourth Amendment. What are police supposed to do when they're out there and they're investigating and they're doing what police do?
When police are on the street talking to people presumptively innocent, trying to find out information, or even trying to find if that presumptively innocent person is someone they're looking for, and they start becoming uncomfortable and thinking maybe this isn't good, they are allowed to walk away. They're allowed, if there's no evidence that that person is a criminal or has done anything criminal or is engaged in anything criminal, rather than say, "I think I'm feeling uncomfortable, I'm going to frisk you," they are as allowed to walk away as the person being questioned is. That's the way our society is meant to work. And Judge Brown, quite properly, in my view, said that what happened here is that after they knew this young man was not the kid they were looking for, the officer, merely by the fact that he was acting a little nervous and then didn't want to answer any more questions, which was his absolute right, said, "Do you have any weapons?" And the defendant didn't want to answer. And so he said, "Well, I'm going to frisk you." He didn't have to do that. As soon as he knew it wasn't the young man he was looking for, he could go, "You can go now." And believe me, under all the facts, it was obvious, Martin, he already wanted to leave. The police officer said he wanted to leave. He wasn't reaching for a gun or going for his waistband. The officer didn't see any bulge in his pocket. He didn't do anything furtive around any area that he'd have a gun. The officer was free to leave. It's a great question, and it's an important question. But this isn't the case where police were genuinely in danger and frisked somebody for their own protection.
The Commonwealth argues that taking the answer to the question that he was 17 and his failure to answer the question that do you have a gun or do you have any weapons allowed the police to infer that he was underage and had a gun, which is a crime. What do you say about that?
Well, it certainly allowed them to infer he was underage. He said he was, no question about that. But the leap that suddenly, because he didn't answer a question, which was his absolute right, meant he had a gun?
Well,
No.
I think the lesson you'd have to get from this case is that once you start answering questions, you can't stop, because you have the right to not answer any questions. But if you start answering and then you don't, I mean, if the appeals court is right, if you start and then stop answering questions, that gives reasonable suspicion.
Well, I see your point. I guess I try to put myself in this kid's position. Police are bugging me. They want to talk to me. They want to talk to me. I'm walking down the street, and finally I start, okay, you know, here's my name, here's my fake,
So you're saying
here's my fake age. I might lie about my age, too. And suddenly I go, you know, I don't want to answer more of these questions.
does your
That's
case,
my right.
Does your case
I don't want to be frisked under those circumstances.
Does your case depend upon a conclusion, our concluding that the seizure took place before the police said, I want to frisk you?
I don't think it does, Your Honor, no.
Okay.
I don't think anything had happened between the earlier sort of, as I say, non-consensual nature of the encounter and that moment. I don't think so.
Well, at what point, if the police continue to ask a person questions, which they have the right to do, and,
Yes.
and the person has the right not to answer,
Yes.
how long can the police persist in following them and continuing to ask questions? How long can they continue to do that? Or and if there's a point, did they cross the line here?
I guess I do want to back up and answer your first question. I suppose if the case is going to turn on whether, as Justice Cowan suggests, once you start answering questions, and then if you won't answer a question, that is permitted to create a reasonable suspicion, then my case does turn on that moment, because the police said it's only at the moment that my client wouldn't answer that particular question that the officer said, I'm going to frisk you. If you remove that fact and move back a little bit in time, and now getting to your second question, how long are they allowed to keep questioning? Well, they're allowed to keep questioning, but they're not allowed to infer that somebody's got a gun because someone says, I'm 17, no, I'm 19.
You don't contend, though, that the defendant answered the question about his age after he had been seized?
Let me think about that. I do contend that.
I thought you
I'm
said
putting
this-
myself as a reasonable person in his shoes.
I
Yes.
thought you said the seizure was when the officer said, I'm going to frisk you.
At the latest. But
Yeah,
in my
you
brief,
say
I
it
also
occurred
argue
earlier,
it was
too.
earlier. And I think it was earlier when the police, there's something very non-consensual about the whole way this thing began. There's something that makes me feel intimidated if I imagine police driving down the street next to me, and I'm not answering, but they keep calling out questions until I do. To me, that is a non-consensual answer right there.
Why do you say this is not a Fraser case? Because I'm reading from the appeals court decision, and they say, based on the judge's factual findings, we conclude that the defendant was not seized until the officer attempted the pat frisk. At that point, the officer had a legitimate reason for being in the immediate proximity of the defendant. That's the Fraser language. So
It
why do
is,
you say
except,
this
well,
isn't
the
a Fraser
appeals court sort of stepped over the fact that he was seized at the moment the officer said, I'm going to frisk you. That's a stop. The next thing that happened was the frisk. So that's a,
Oh,
that's,
I don't know. The officer attempted the pat frisk could be when the officer said, I'm going to pat frisk you.
No.
in my view, that's the stop. So the stop preceded the frisk. Officers don't always do that. As Justice
So when
Ireland
you-
is saying, sometimes there's a lot going on and the
So
officer's
what
uncomfortable,
happened-
and suddenly he's just saying, stand right there, starts to
What
pat
happened
down.
between your view of the stop and the actual frisk?
I'm sorry, Your Honor?
You said, in your view,
Yes.
the pat frisk was when the officer said, I'm going to pat frisk you.
That was the stop. That
And
was
then
the seizure.
what happened after that?
After that, then he began, I think I can't remember the exact thing that happened. He said, I'm going to frisk you. The defendant was not, he said, settle down, something like that, and began to,
Well, he
went to
reached
pat
out
frisk
and
him.
the
So what I'm
defendant-
saying is nothing turns on that. I don't,
Well,
nothing
I'm-
turns on your saying, well, I think the pat frisk is when I said I'm going to pat frisk you, or when he did. There
No,
were
the
no new
seizure.
facts. I mean, the seizure was
The
a
stop.
stop
You
is a
were
seizure.
trying to avoid having to ask us to take the bigger step of overruling Fraser. Is that-
Well, I'd like to ask you to do that.
I understand that's if you're sort of going
My
for the
client's
easier part.
interests require me to point out that there was a stop before there was a frisk in this case. Wherever that stop occurred, even if it was the announcement without touching the defendant, I'm now going to frisk you. That's the moment at which a reasonable person would understand they were not free to leave.
Well, that's right.
And
but-
that's the point at which my client was not allowed to, before the officer put his hands on him, was not allowed to go no and walk away. So there is a distinction sequentially, and I
No, but
against
I'm
my
asking you,
wishes
what
to
does
argue
the-
for the overturning of Fraser,
But what difference does the distinction make, is what I'm asking.
well, perhaps it doesn't. Perhaps Fraser oughtn't to have overlooked that distinction.
You're out of time, but I did want to ask you on the Melendez-Diaz issue.
Yes, Your Honor.
Apart from the certificate of that it was an operable weapon.
Yes.
Was there any other evidence in this case that,
Well-
that the weapon was operable?
The Commonwealth has said that the judge could have looked at that weapon himself and decided that was sufficient, but that's not how the case was tried. If you look at the, 5-sentence closing argument here, the prosecutor said, we've got a certificate from a ballistics expert, that's enough. So that's how it was tried. So the judge was only directed, his attention was only directed to the ballistics certificate, and that was the end of the case. So, and furthermore, if it's true as a general principle that without the certificate, the judge himself could have examined the weapon and decided it was a firearm, that takes away my client's right to cross-examine that ballistics expert, which may have changed the judge's mind.
And certainly the test was an issue, was a live issue at
Yes, it
trial.
was, Your Honor, you bet. The Commonwealth notes that we put in the record the evidence that the defense was relying on, but we didn't do that without getting permission. We asked the appeals court for permission to add that document to the record, and we're allowed to. It's the last one in the
Ms.
appendix.
Siverson, I think I know the answer, but obviously, at least with respect to the post-Verdi pre-grant cert of Melendez-Diaz, and
Yes.
because the crimes that involve drug certificates and weapons certificates are ubiquitous. There are hundreds of them.
Yes.
As you could tell, we have been looking for guidance from counsel. You are an experienced appellate attorney. What do we do? What's the, there are lots of people who were filing objections to ballistic certificates and drug certificates in the Commonwealth of Massachusetts, if I'm to believe the appeals court, and I have no reason not to. They were objecting. What do I make of that?
If the Commonwealth's data concerns lots of people objecting since post-Melendez-Diaz?
No. Post.
Well, actually, I pointed out in my brief that in the Verde case, the Commonwealth filed a brief, I think as amicus curiae. The DAs filed an amicus brief in the Verde case. And
Yeah, I
I
saw
noted in my
that.
brief, and they said hardly anybody ever objects to this stuff.
No, I've now got a footnote in the. Do you know to which I'm referring? In the Vasquez case, there's a footnote where the
Yes.
appeals court purported to go through all of the pending post-Verdi pre.
Yeah.
Um,
Oh,
cert-
post-Verde, I see.
Post-Verdi pre-cert granted.
Yes.
Now, as you heard,
I don't know the
I don't know
answer
if you
to
were
that.
here this morning, but as I said, there are lots of reasons why one would continue to object after
Yes,
Verdi.
that's true.
One of which is that you haven't read it,
Yes.
right?
Yes.
Another of which is that you've got an immigrant on your hands and
Yes.
you're looking towards the,
Absolutely.
you've got to cross every T, dot every I. The question is, why would we not regard a non-objected, where certificate drug ballistics has not been objected to, why would we not look at that under the substantial risk factor?
If you're asking me as a general principle, it's not my case. My client's defense lawyer objected to the introduction of it.
I know. And we've got, by the
Well-
way, 3 other cases on Friday. I mean, not on Friday, next month, December.
It seems to me that if this court has squarely ruled no constitutional problem with that evidence, Massachusetts Supreme Judicial Court has had the issue squarely before it and said there's no problem with this, then your ordinary reasonable lawyer is going to go, that's the law. I don't have to object on, why should I object on that basis?
And the counter to
granting
that
of
is,
cert-
we are not the, if it were Article 12, Article 14, no question.
Yes,
But this is
yes,
confrontation in the United States
yeah,
interpretation of its confrontation clause, which binds all of us.
yeah. I guess my answer would be that the fact that cert's been granted is no indication that the law has changed. And, maybe the most great lawyers on the planet are absolutely tracking every case that the Supreme Court accepts cert on and projecting that the defense is going to win, which rarely happens, but I don't think that should be the determining factor. I think the fairness of the trial should be the determining factor. And where you have, these cases often turn solely on a piece of paper. That's the big thing. I mean, I think that's what's so important. This is not a case where, or these aren't cases where there's lots of evidence of other things, and the certificate is only cumulative. It's invariably the sort of thing that the case turns on, whether it's a firearm or a drug case.
Thank you, Ms. Sivison.
Thank you, Your Honors.
Ms. Celio, good morning.
Good morning, Your Honors. May it please the Court. Kathleen Celio on behalf of the Commonwealth. I ask this Court to affirm the defendant's convictions. The motion judge here properly denied the defendant's motion to suppress. Because at the moment that Officer Henriquez announced that he was going to pat frisk the defendant, he had a reasonable belief that the defendant, under 21, was armed and dangerous, and thus both had reasonable suspicion and a reasonable fear for safety at that point.
Are you saying that the reasonable suspicion is that he was committing the crime of an unlicensed carrying of a firearm? Is that what you're saying?
Yeah, he was under. Yes, he was under. He alleged.
Oh, wait a minute. You have to talk a little slower, Ms. Celia. So, from the Commonwealth's point of view, when he said, "I'm going to frisk you," we've got a seizure. Ms. Sibison says it's actually before that, but let's at least for now say it's at that moment. And then you say they have a reasonable suspicion that he's armed and dangerous because of what?
No, I was asking reasonable suspicion, first step, that he's committing right there the crime of unlawful carrying of a firearm because he's under 18 and they have a reasonable suspicion, I guess, that he has a firearm.
No, that's what I'm
that
choking.
based on?
What's
the
that based
reasonable
on?
suspicion that he had a firearm?
Yeah.
It is the factors that gave rise to the officer's belief that there was a danger, and it was,
What are those factors? I mean, he's walking along, right? And they're two of them, they're adult, they're in a car, they're shouting questions at him, right? Have they identified themselves as police?
they have, Your Honor.
Okay, so he keeps walking. And, we've said 1,000 times, oh, well, you can keep walking. Well, it turns out apparently that you can't keep walking because the police continue to follow you, right? And they can keep shouting questions at you. Shouting at you, correct? They're shouting from the car.
There was no evidence that they were shouting. There's no evidence of that. They were asking him questions. The police in this situation thought the defendant looked like the juvenile that they had arrested.
Yeah, but they've decided long before they decide to pat frisk him that he's not that person.
It was only at the point when they were face to face with the juvenile. That's what the motion judge found, and that's consistent with the officer's testimony.
But the question I think that we're asking is, on what does he base, Henriquez, the conclusion or assumption or whatever that this person is carrying a firearm?
You have multiple factors here that the appeals court recognized. You have the officers, when they asked the defendant his name, the defendant hesitated. And then they asked him his age, still kind of trying to ascertain whether or not he's the juvenile, constantly looking at the defendant's face. They could not see the defendant's face until he was face to face to ascertain whether or not he was this juvenile. So we asked the defendant his date of birth. Gives him 17. He hesitates before that again, making the officer think maybe he is lying to me. So we asked him.
Yeah, so let's say he's lying to him.
So how does that get you to a reasonable suspicion that he's carrying a firearm?
Well, it was the progression of the encounter.
It's a reasonable suspicion that he's lying and that he's got something to hide, but why is it a gun?
Because when the officer asked the defendant, do you have a firearm or anything that I should know about, the defendant went silent.
Well, why shouldn't he? Doesn't he have a right to remain silent?
He does, but the officer taking,
Oh,
recognizing the,
So we can instruct a jury, members of the jury, you've got a right to remain silent, but you can draw a negative inference from that?
but this court has recognized and courts recognize an adoptive admission when
An adoptive admission?
the defendant was asked, do you have a firearm?
No, an
I thought he was
adoptive.
asked, do you have a weapon?
Do you have a weapon or anything I should know about?
And does he have a right to remain silent at that point?
He doesn't have to answer that question.
He doesn't have to answer that question.
But
No. Does he have to answer that question?
But
No. Does he have to answer that question?
he does not. But in looking at the reasonableness of the officer,
No. So he does not have to answer the question. He has a right, for about 6 different reasons, not to answer that question.
But-
Correct?
that is correct. But in the
Are you, I'm walking along. Are you dealing in what's your name? I give a name. What's your age? I probably give the wrong age. Are you dealing in marijuana? Oh, adoptive admission. I can frisk you.
no, we have not only that, but we have the defendant.
Now, isn't that essentially what happened?
But this court has recognized in both Frazier and in Johnson that the police officer said, take your hands out of your pocket. The defendant had a right not to take his hands out of his pocket. And this court recognized that
Yeah,
that
but
was
that's
a
a
factor.
little different than being questioned by the police.
I don't see the difference because
Because you say if I'm walking along and I keep walking, don't want to talk, and the police question me, there are 2 of them, one's sitting in the driver's side, but he questions me, not shouting out to me, he questions me, and then I say, okay, so I give my name, yeah, so maybe I don't give the correct age, and then he says, do you have any marijuana on you?
correct. What?
And then they can frisk me?
No, that situation is entirely different.
Why?
One,
Why?
Well, why wouldn't that be reasonable suspicion to believe he has marijuana on him? You said that, failing to answer the question, do you have a weapon, creates reasonable suspicion that he had a weapon. Why isn't the other true?
well, because we just had more than that question. We had his hesitation about his identity. This court has recognized that trying to conceal something that was in DePesa, trying to conceal something can contribute to reasonable suspicion for a stop. And then you have the defendant's, it was his obvious nervousness. The officer testified.
But
when,
we've also said that it's, I don't know about you, but maybe it's just me. I'm driving down the highway and I see a police car. What do you think I do? Before I look at my speedometer, I take my foot off and I immediately why? I don't know.
correct.
Nervousness has got nothing to do with the fact that I'm in fact driving over the speed limit. 9 out of 10, I hope 10 out of 10 times I'm not.
This defendant's nervousness was evident by the fact, and it wasn't just blanket nervousness. It wasn't the officer testified, oh, he was nervous. The officer testified the defendant was so nervous that it made the officer feel nervous. And this came from the fact that the officer got out of the car, still trying to ascertain whether or not this was the juvenile. And that
He was standing in front of him?
the officer, as the officer got out of the car, the defendant took steps back. And that as he was approaching, that he was looking back and forth, and that he was shifting his feet. And the officer testified that it appeared to him that the defendant was going to run. This court has recognized in DePesa and Rock that shifting feet, that the way that the defendant was moving did add to reasonable suspicion.
But the difference between this and DePesa is that there was evidence that he was actually carrying something that the officer, the court said, the officer reasonably suspected was a firearm. We don't have anything here. Basically, you've got a reasonable suspicion that the young man is lying to us and he's trying to hide something, but that doesn't translate into a gun.
But then when the officer reasonably, this is all that is required. The officer in this position is feeling nervous for himself. The officer testified that based on the defendant's nervousness, that he became nervous himself. And that based on this nervousness, he reasonably then asked the defendant if he had a weapon.
But why couldn't it have been a knife? And you don't have to be licensed to have a knife, do you?
You don't. But the officer testified that the way that the defendant was acting, it appeared to him that he had a firearm.
What was it about the way he was acting that made him think it was a firearm as opposed to a knife or a pencil or something, a knife?
The officer never said why it appeared to him but as a firearm, but the officer had testified that in his experience that the way that the defendant was acting, his hesitation, and that his obvious nervousness that made him fear for his safety. And he just asked, do you have a weapon or anything I can know about? I think that with the defendant's silence at that point, the moment of seizure only occurred afterwards.
Well,
the officer
just
could
finish
think
that. With the defendant's silence at that point, what?
that the officer had a belief that the defendant did in fact have a weapon on him.
So the level of nervousness, I take it, is greater for a gun than it is for a knife.
That is correct.
How
That's
can
an
you
inference.
say that? I mean, that a person will be more nervous because they had a gun than if they had a knife?
Well, the officer actually testified that in this case in which he had done over 100 pat frisks, and that in the situation where a defendant is nervous, such as the defendant in this place, and in this situation, and the defendant was trying to flee in situations like this, he said that he had recovered half of the time he had gotten firearms.
Half of the time? And what about the other half time?
He had not. But
Well, so 50%, I mean, the issue here is the balancing of the rights. Most of the cases we see, because, somebody gets stopped, they get frisked, and they don't have a weapon. We don't see those cases. So it always seems very convenient to say, well, he had a reason to believe, and guess he was right, because they recovered a weapon.
But I think that it adds, when you're looking at the reasonableness of the officer's
The reasonableness of the
nervousness.
officer might be to stop everybody and pat frisk them. Because these days, a lot of people carry guns, and if the United States Supreme Court says that the Second Amendment is incorporated into state law, believe me, a lot more people are going to be carrying guns. So it might be reasonable for officers to stop and pat frisk everybody whenever they want to question them.
It's not illegal to have a knife, though, is it?
For a juvenile.
A dangerous weapon. You have to. I think it's per se dangerous.
Can we separate this out? Obviously, the district court judge found there was no reasonable suspicion to believe a crime was committed, no reasonable suspicion to believe the person was armed and dangerous, and that the only basis here was the pushing of a way which gave the police probable cause. They could have arrested him, therefore this search was okay. Are you rejecting that
No.
the reasoning of the district court?
No, I think that it was an intervening and independent act that dissipated the taint of if there was.
Well, you're saying there's
illegal-
no taint to begin with, but even if there was, the district court judge is right. This is an intervening act that makes it all okay.
Yes, the defendant was actually convicted of this crime, of assault and battery, and the defendant's not contesting the sufficiency of that crime. And I think that this would be the first time that the court would hold that the defendant in committing a crime against an officer, it would not constitute an intervening act.
So let's take it one step at a time. If we say, like the district court judge, there was no reasonable suspicion to believe this person was committing a crime, therefore no constitutional basis on which to stop him, seize him.
Mm-hmm.
Are you still saying, well, that's all well and good, but under Frazier or the Frazier line of cases, because the officer was reasonably concerned about his safety, the pat frisk was okay? Even though there was no reasonable suspicion to believe this person was committing a crime, the pat frisk was okay because the officer reasonably feared for his safety.
Yes,
Okay. So either way.
correct.
Are you also saying that if this officer had just randomly stopped somebody on the street with no basis, and the person had pushed him away, that alone means he can frisk him and the frisk is okay?
That he, at the time that the defendant commits an assault and battery on a police officer, he has probable cause to arrest him and can search into an incident to that arrest.
But the problem here, and I want you to explore that, from the record, he pushed him away, the officer said, calm down, and then he went on and frisked him.
Mm-hmm.
He didn't say you're under arrest for assault and battery. He didn't do a search incident to arrest. He didn't seem to treat it as if it was, at that time, an arrestable offense until after he found the gun. What consequence, if any, is there that that's how it played out?
I mean, I don't think that you can take from this that the officer wasn't concerned about the assault and battery that the defendant had just committed against the officer, just because he didn't say, I'm going to arrest you now for assaulting me. And
Case that says, if I think I'm right, that it doesn't matter whether the search precedes, comes just before or just after the arrest, that isn't the key.
that is correct.
Yeah, but my question would be that isn't the whole arrest for assault and battery the result of the fruit of a poisonous tree? Because it wouldn't have happened but for this whole thing that the police shouldn't have been doing.
But that occurs in every case in which you find an intervening act. That absent,
The intervening act here that attenuates the circumstances.
it
So
is
that-
the assault on the police officer. The defendant was convicted of this crime of assault and battery, and that gave.
So, I mean, your point is if the car had been pulled over illegally and the police officer went up and began to question the person, and the person then punched him, that
Yeah.
would be an intervening act, which essentially, if they found stuff in the car when they placed him under arrest, that would be okay.
Yeah, and I think the appeals court at least recognized that. I think it was a pushing of the car door against the police
Celia,
officer.
let me just follow up on Justice Gans. So there's no, I'm walking along. I haven't answered or not answered questions, but a police officer comes up to me and starts to do this, right? As if to pat frisk me. No basis, but that's what he does. And I push his hands away. Right? You say I must never do that because that's an assault and battery, because all that happens is he pushed their hands away. What I should do is stand still and let the police officer pat frisk me.
Yes. And
Even if no reasonable suspicion that I've committed a crime or about to commit a crime, no reasonable suspicion that I'm armed and dangerous, I, as a citizen, have to stand by and let the police officer pat frisk me.
yes, and absent egregious police misconduct, which is court. I mean, it's in the law. And
Which case says that
That
they can
the intervening-
walk up to an innocent citizen and pat frisk them?
there is no case exactly.
Yeah, but don't you find it a little strange that in our society, if a police officer comes up to a woman walking down the street with obviously he's a police officer and says, I'm a police officer, and starts to pat frisk her, if she so much as moves or pushes him away, that she can't do that?
No, as the motion judge found, that if individuals start to take their own action against police officers, chaos
I'm not
and
taking
violence.
action against police. I'm just stopped some man from patting me.
That a person cannot retaliate against a police
I'm not
officer.
retaliating.
In choosing to take into your own hands.
I'm not choosing to take into my own hands. Somebody is a police officer, and with absolutely no basis that I can see, just starts. And you're saying I've got to just stand there?
That is consonant with this court's analysis too on illegal arrest. That you can still resist an illegal. You cannot
hardly
resist an illegal arrest. And it's for the same thing. It would be dangerous to the officers in those situations to allow individuals to be able to just start assaulting them based on the police conduct. And this court has no further questions. The Commonwealth will rest on its brief.
Thank you, Ms. Celia.